We make promises all the time, but have you ever stopped to think about what separates a casual promise from a deal that a court would actually enforce? What's that magic ingredient that turns words into a legally binding contract? Well, today we're diving deep into that very question.
So let's just start right there with that central puzzle. If I promise to sell you my car and you promise to pay me for it, that feels like a contract, right? But what's the legal machinery that makes it stick? It really all boils down to one crucial, powerful concept. And that concept is consideration. Honestly, the easiest way to think about it is as the price you pay for a promise. Under the Indian Contract Act, it's just something of value that one person gives in exchange for what the other person is promising. It could be an action, like, say, painting a house. It could be not doing something, like promising not to sue someone. Or it could even be another promise. The key thing to remember is, for a contract to be real, both sides have to bring something to the table.
All right, so to really get how this price works, we're going to look at 4 key areas. First, we'll ask who can actually step in and enforce a contract. Then, we'll get into the really tricky question of whether doing a job you're already supposed to do can count as a new price. After that, we'll see how the law steps in to keep things fair. And finally, we'll check out some surprising times when a promise is binding even without any price at all. Okay, first up, contracts and outsiders, and this puzzle called privity. This brings up a really basic question. If you and I make a deal that's meant to help a third person, can that third person sue if one of us breaks the promise? I mean, who actually gets a say here? Well, the traditional rule, which comes to us from English law, is super strict. It's called the doctrine of privity of contract, and it basically says only the people who are actually in the contract, the ones who shook hands on the deal, can sue over it. If you're an outsider, even if the whole point of the deal was to benefit you, you're usually out of luck. You have no legal standing. A couple of classic English cases really show this rule in action. In Tweddle v. Atkinson, a groom's father and his future father-in-law made a deal to each pay the groom some money after the wedding. Well, the father-in-law passed away before he paid up, and the groom's lawsuit to get the money failed. Why? Because the contract was between the two fathers. The groom was just supposed to benefit. He hadn't given any price himself. Then you have Tires v. Selfridge, where a tire manufacturer couldn't directly sue a retailer for selling their tires below a minimum price. Why not? Because the manufacturer's agreement was with the dealer, not the retailer. There was no direct link, no privity. But hold on, because this is where Indian law takes a really different path. You see, English law demands 2 things. Privity of contract, you have to be in the deal, and privity of consideration. The price has to come from you. The Indian Contract Act, though, is much more flexible. Section 2D has this game-changing little phrase. It says consideration can be provided by the promisee or any other person. This is huge. It means while you still generally need to be a party to the contract, the actual price for the promise doesn't have to come directly from you. The famous case of Chinnaya v. Ramaya shows exactly how this works. Here's the story. An elderly woman gifted some property to her daughter, but there was a catch. The daughter had to promise to pay a yearly sum to the woman's sister, her aunt. The daughter agreed, but then, well, she stopped paying, so the aunt sued her. Now, under the strict English rule, the aunt would have lost because she didn't provide any consideration herself. But the Indian court said she could sue. Why? Because the consideration, that big gift of property, was provided by her sister, the mother. And since Indian law allows consideration to come from any other person, the aunt had every right to enforce the promise that was made for her. It's funny, even the super rigid English system found clever ways to get to a fair result. In a case called Beswick versus Beswick, a nephew promised his uncle that he'd pay an annuity to his aunt after the uncle died. He stopped paying, and the aunt couldn't sue in her own name because of that privity rule. But she was also the administrator of her late husband's estate, so she sued him in that role as the representative of the estate, and she won. It was a really clever legal move to make sure the original promise was kept. Okay, on to our next puzzle, the pre-existing duty rule. Let's say you're already legally bound to do something. If someone comes along and promises you extra cash to do that exact same thing, is doing your job valid consideration for that new promise? Can you get paid twice for one job? This is a fascinating story of how the law has evolved. It starts way back in 1809 with a super strict rule. And it ends almost 200 years later, in 1990, with a much more realistic approach that actually understands how business works. So the old rule comes from this case, Stilk v. Merrick. Picture this. A ship is on a long voyage and 2 sailors desert.
The captain is in a tough spot and promises the rest of the crew he'll split the deserters' wages among them if they just sail the ship home safely. They do it, but later, the captain refuses to pay up. And the court actually sided with the captain. Their logic was pretty harsh. The crew's original contract already required them to handle any ordinary emergencies of the voyage, so by sailing the ship home, they weren't doing anything new to earn that extra money. No new consideration, no new contract. Now let's jump forward to 1990 and the case of Williams v. Rafi. A contractor hires a carpenter. Partway through, the carpenter realizes he's in financial trouble and can't finish the job. Now, the contractor is facing a big penalty if the project is late, so he promises the carpenter extra money just to finish on time. Later, he changes his mind. But this time, the court's decision was the complete opposite. They said the promise was enforceable. Why? Because the contractor got a practical benefit from the carpenter just doing what he was already supposed to do. So what exactly was this practical benefit? Well, it was very real. By getting the original carpenter to finish, the contractor avoided that big late penalty. He also saved himself the headache and cost of having to find a new carpenter mid-project. And he got the peace of mind that the job would be done right and on time. The court basically said, hey, that's a real, tangible benefit, and that's valuable enough to count as fresh consideration.
Okay, but what about those situations where there's no technical consideration at all, but it would just be totally unfair to let someone back out of their promise? This is where the law pulls out a special tool to ensure fairness. It's called promissory estoppel.
There's this great legal saying, promissory estoppel is a shield, not a sword, and it's the perfect way to understand it. It means you can use this doctrine as a defense, a shield to stop someone from going back on their word when you've relied on it. But you can't use it as a sword to start a lawsuit and create new rights out of thin air. It's a protective measure, plain and simple. The classic example that everyone learns is the high trees case. During World War II, a landlord agreed to cut the rent in half on a block of apartments because, it was wartime and not many people were renting. The tenant relied on that promise and paid the lower rate for years. Then, after the war, the apartments were full again, and the landlord sued for all the rent he had missed out on, at the full price, for the entire war period. The court said, absolutely not. The landlord was estopped or blocked from claiming that back rent. He couldn't go back on a promise that the tenant had clearly relied on. That was the shield in action. And that brings us to our final section, which is really fascinating. It's where the law itself says, you know what, in these specific situations, a price just isn't necessary. Section 25 of the Indian Contract Act is very clear that agreements without consideration are usually void, but it creates some very important, very human exceptions. These exceptions really show you what the law values beyond just cold, hard cash. First, if a promise is made between close relatives out of natural love and affection, and it's written down and registered, it's valid. The law acknowledges that family bonds are a form of value. Second, family arrangements made just to keep the peace and avoid fights are also upheld. The law sees value in preserving family harmony. And finally, if someone does you a favor voluntarily and you later promise to pay them for it, that promise is binding. It's the law's way of saying that a moral obligation can be legally enforceable. All right, let's wrap this all up. What are the big takeaways? First, consideration is just the price of a promise. Second, Indian law is way more flexible than English law, allowing that price to come from a third party. Third, a real-world practical benefit can be enough to count as consideration, even if you were already supposed to do the job. Fourth, the law has a fairness shield called promissory estoppel. And finally, some promises, especially within families, are so important that they don't need a price at all.
And that leaves us with one final thought to chew on. We've seen the idea of a price get stretched and adapted over time, from a strict exchange to a practical benefit to sometimes disappearing entirely in the name of fairness. It really makes you wonder, if the ultimate goal is to be fair, just how far should the law be willing to bend the definition of a price to make a promise stick?